Good evening and welcome to the launch of Volume 46, Issue 4 of the University of New South Wales Law Journal. On behalf of the journal, I would like to begin by acknowledging that we're meeting on the lands of the Gadigal people of the Eora Nation. I pay my respects to their elders past, present and emerging, and extend that respect to any Aboriginal or Torres Strait Islander people here tonight. Just some quick housekeeping before we start. We've been asked that everyone stay on this level of the building and that you don't enter any meeting rooms because there are some meetings in process. My name is Matilda Grimm and I am the Executive Editor of the University of New South Wales Law Journal. It is my privilege to welcome you to the launch of Volume 46, Issue 4 here tonight. This issue is a part thematic issue on the topic Power, Workers and the Law. My thanks go first and foremost to King Wood Mallesons as our host for this evening. The journal is very grateful for their ongoing support, without which much of what we do would not be possible. My special thanks go to Sarah Morrison for putting tonight's event together and also to Andrew Gray for speaking on behalf of the firm shortly. I would also like to recognise the very generous support of our other premier sponsors, Cause Chambers Westgarth, Herbert Smith Freehills and Allens. We're excited to welcome virtually tonight Professor Keith Ewing, Professor of Public Law at King's College London and a Senior Fellow at the Melbourne Law School. Professor Ewing wrote the foreword to this issue and will shortly deliver a keynote address on the thematic topic. The journal extends its sincere thanks to Professor Ewing for making the effort to join us all the way from across the world. There are several other people whose support is integral to the journal. Our brilliant faculty advisors, Professors Rosalind Dixon and Gary Edmond, who always lead with a steady hand, and Professor Andrew Lynch, Dean of the UNSW Faculty of Law and Justice, who is a great champion of the journal and whose ongoing support we treasure immensely. We are thankful also to Professor Lyria Bennett-Moses for her generosity in agreeing to deliver the vote of thanks at the conclusion of tonight's official proceedings. My congratulations as well to each of the authors featured in this issue, some of whom we're glad to say are here tonight. Thank you for trusting us with your work and for putting up with what we have heard is a very rigorous editing process. I hope you will view it all as worth it once you see your work in your hands tonight. There are various other parties whose direct and indirect support ensures a night like tonight can happen. Printers, typesetters, cover designers, artists, photographers, videographers, UNSW law staff, peer reviewers, family, partners, friends, the list goes on. But undoubtedly the most important contributors are our editorial board members. Editing is a marathon, not a sprint, and our editorial board members are seasoned athletes. Thank you all for the work you have devoted to the journal in 2023. I hope you are proud to see your name in print in the front matter of this issue. It has been my great privilege to lead this journal for the past year and to work so closely with all of you. I'm very proud of what we've achieved this year and can't wait to see what the journal gets up to next year under the helm of our new executive editor, Sharanya Murthy. I'm also pleased to welcome to the executive committee Rachel Lowe, our new digital editor for 2024, Marcella de Torres, our new forum editor, and although he has already been with us for a little while, Anna's successor, Rowan Gray. The launch of the final issue for 2023 means that my, Jack Zhao, Zong Guan, and Anna Ho's time on the executive committee is coming to an end. I would like to thank Jack, Zong, and Anna for their tireless dedication to the journal over the past year and wish them all the best with whatever comes next. I'm so grateful to be able to call all the members of the executive committee my friends. I must confer particular praise on Anna as editor of this issue. Over the past 15 or so months, Anna has dedicated herself wholeheartedly to the journal and has firmly established herself as a stalwart of the journal community. Anna is a fantastic mentor, friend, activist, and editor, and I can't wait to see what she applies her energies to next. Thank you all for joining us at the launch of Volume 46, Issue 4 tonight. It is now my pleasure to introduce Andrew Gray, partner in the Employee Relations and Safety Group at King Wood Mallesons, to welcome us to the firm.
Thanks, Matilda, and thank you everyone for joining us tonight. I'll be very, very brief. Hopefully everyone have a wonderful evening. It's great to see some friendly faces in the audience. it's great to actually hold a real book again and a journal. It's been a long time since I've done that. But can I just pass on my compliments to the editorial team and the authors for picking such an amazing range of topics. As an employment lawyer, I forwarded the list of topics to my team this morning and said, look, have a look at some of these. If you'd like to come along tonight, please come along and join the evening. Daniel and my team, I can see, has already started to read the article on non-competes, so there you go. But the overwhelming feedback from the team was, well, what a fantastic set of articles, and it must be quite challenging to cover some of the topics such as wage theft and the like when, in fact, as we sit here, the laws are literally changing and being introduced through Parliament last week. So an amazing set of topics, very informative for both academics and, I think, from my perspective, the profession as well. And it's wonderful to see this sort of work being done in such an exciting and ever-changing area. So with that, I'll ask Anna to come and speak further.
Thank you, Andrew, and thank you, Matilda. I'd like to begin by acknowledging that this launch takes place on the unceded land of the Gadigal people of the Eora Nation and pay my respect to their elders past and present. Acknowledging country is always important, and I think especially so tonight in light of the theme of this issue launch, which is power, workers and the law, because we cannot fully understand Australian labour history without acknowledging the pivotal role played by First Nations workers. For example, many people here will know about the 1966 Wave Hill walk-off, when 200 Gurindji stockmen from Wave Hill Pastoral Station went on a strike that ended up lasting for 3 years. It was a strike that was in response to their unequal pay and their poor working conditions. But the strikers also made a land claim to the Australian government to demand the handing back of their traditional lands. In this way, the walk-off wasn't just an industrial struggle, but a land rights struggle as well. And now it is recognised as a major event leading to the legislation of the Aboriginal Land Rights Act in 1976. More than 50 years later, this year, staff at the University of New South Wales bargained for, went on strike for, and achieved in their new enterprise agreement enforceable First Nations employment targets. I end this acknowledgement with a quote from Murray Elder Lilla Watson. "If you have come here to help me, you are wasting your time. But if you have come because your liberation is bound up with mine, then let us work together." It is in that spirit of solidarity that I acknowledge that this always was and always will be Aboriginal land. Thank you all for coming to celebrate the launch of issue 46.4 of the University of New South Wales Law Journal. Tonight is first and foremost a recognition of the work of the 24 authors in this issue, some of whom we are lucky to have here tonight. Now, for some editors who get asked what their favourite article is, it's like choosing their favourite child. Straightforward enough, that is. But luckily for all of you, I lack that kind of maternal instinct and can happily recommend all 10 articles in issue 46.4. So let's start with the general component of this issue. The first 2 articles look at the COVID-19 pandemic. First, at how the pandemic exposed core democratic failings of our Commonwealth, state, and territory parliaments. And second, how policing and our criminalisation paradigm undermined public health objectives during the pandemic. I'm personally really proud that our journal is publishing work about the COVID-19 pandemic a few years after its peak, not only because the virus is still very much present today, but because pandemics and other global crises are with us to stay and expose as many problems in our governance as they create. The third article in the general component compares the Canadian and Australian courts' approaches to the integration of customary international law in domestic common law, focusing upon the Canadian case Nevson Resources Limited and Araya. Finally, Catherine Waller and her co-authors compare voluntary assisted dying legislation across all Australian states, which is actually very topical for those of us in this room because the Voluntary Assisted Dying Act in New South Wales came into effect just 2 weeks ago. The thematic component of this issue and tonight's launch theme is power, workers, and the law. focusing on employment and industrial relations law. The first 3 articles look at recent legislative changes, some of them very recent indeed. The impact of last year's Secure Jobs, Better Pay Act on Australia's collective bargaining and strike laws, a framework for the criminalisation of wage theft, which was just passed in the Closing Loopholes Bill, and an intersectional feminist critique of the Workplace Gender Equality Act, which was amended earlier this year. The next 2 articles look at how the courts have interpreted the employment relationship, first in relation to non-compete restraints, and then in the High Court's new contract-focused interpretation of employment. The thematic component ends by looking to the future, addressing how climate change will affect the future of work, and how unfair dismissal, collective bargaining, and work health and safety laws should adapt to meet that crisis. Without overlooking the nuances of the thematic articles in their own right, I think overall they consider the idea of power and work in 2 key ways. The first is how the law affects power in an individual employer-worker relationship. Famously, Otto Kahn-Freund said that labour legislation should counteract the inequality of bargaining power, which is inherent and must be inherent to the employment relationship. The second way the articles consider power is in how the law regulates organised labour. When I proposed this thematic a year ago, it was against the background of Amazon and Starbucks workers unionising in the United States, and here in New South Wales, a public sector strike wave. Since then, perhaps the most globally high-profile industrial dispute has been the Hollywood writers and actors strike, marking the first time in 60 years that writers and actors have gone on strike together. Industrial disputes force us to recognise that it is labour that makes the world run, which is why its suspension is potentially so powerful. And as the editor of an issue focusing so heavily on industrial law, I would be amiss to not recognise the importance of labour during this issue's preparation. To illustrate this, at the very start of my tenure in November last year, I saw in the journal's email inbox a reply from an Australian academic who we had asked if they were able to review an article. The email read verbatim, "Sorry, but after our significant staff cuts, I find myself too busy to review for your journal." Now, during my time as an editor, I've been emailed by many academics asking for a few extra days to return a review or turning down the opportunity to review because they are swamped by teaching, marking, or other obligations. Now, I should preface here in what I hope is a very obvious disclaimer that I am not complaining about our reviewers, who are incredibly generous with their time and comments, and to whom we are indebted as a student-run publication. And I'm also not ignorant of the many demands of academic work. What I am saying is that these responses shouldn't be read outside of the context of the industrial conditions in the university sector, just like the email that I received in November last year. This is a sector, after all, which suffered the loss of 1 in 5 jobs between May 2020 to May 2021. It is a sector where about half of university staff in Victoria are employed on casual or insecure temporary contracts. I saw a photo, for example, from the picket lines at the University of Melbourne from a staff member who had embroidered on their jacket, "I am on strike because I am on my 37th contract since 2017. In fact, some academics we have asked to review for us have explained that they couldn't do so at the time because they themselves were taking industrial action. And so, I repeat, as an editor of an issue focusing heavily on industrial law, I see an inseparable connection between the working conditions at our universities and the quality of the scholarship the journal is able to publish. And I dare say perhaps the diversity of the scholarship we're able to publish, considering that it tends to be women who are disproportionately affected by casual and insecure employment. This is what I will be reminded of whenever I think of my time as a journal editor. But of course, when I think of my time as a journal editor, I will also be thinking of every person who made it so interesting and rewarding. As I said at the start, tonight is first and foremost a recognition of the 24 authors in this issue. Thank you for publishing your work in the journal and for your enormous patience and diligence during the editing process. It really has been a privilege to oversee your articles to publication. Thank you too to the extremely generous anonymous peer reviewers for this issue. Of course, I have to thank the volunteer student editors who make the journal world go round. And my greatest hope is that you found something of worth and interest in the work that you edited so well and so carefully. Thank you to the members of the executive committee I've worked alongside for being smart and funny and capable. And I wish the very best of luck to the editors for volume 47. The journal was also lucky to have the long-term and behind-the-scenes support from many people. Thank you to our typesetter, Kerry Cook, and our cover designer, John Hewitt, for their consistent and excellent work. Thank you to the University Faculty of Law and Justice and our Dean, Professor Andrew Lynch, for their support of our work and our independence. In particular, I'd like to thank Professor Lyria Bennett-Moses tonight for delivering the vote of thanks later on. The executive committee are especially thankful to our faculty advisors, Professors Rosalind Dixon and Gary Edmond, for their advice and experience as highly respected academics themselves. And thank you to King Wood Mallesons, one of our premier sponsors, along with Allens, Calls Chambers Westgarth, and Herbert Smith Freehills. Thank you for hosting tonight's launch and for your continued investment in legal scholarship. And thank you in particular to Andrew Gray for your introduction, and Sarah Morrison, Lauren Schwartz, and Marlon Ramones for your organization and helping tonight run so smoothly. My final thanks go to those who have been very special to me during this issue's preparation. First, to Jackie Adams, whose artwork beautifully opens this issue's thematic component. And finally, to my parents, sister, partner, and friends who have given me nothing but their most perfect love and support. It's now my pleasure to introduce the keynote speaker for tonight's launch. Keith Ewing is a professor of public law at King's College London and senior fellow at Melbourne Law School. He is the president of the Institute of Employment Rights, the president of the Campaign for Trade Union Freedom, and vice president of the International Centre of Trade Union Rights. We're also very lucky to have had Professor Ewing write the foreword for issue 46.4, which thoughtfully considers the fundamental principles which should inform Australia's labour legislation if we are to give effect to our international labour obligations. And I'd also personally like to thank Professor Ewing for being very accommodating with AV sound checks at quite antisocial hours at London time. Please now make him feel very welcome.
Good morning. Thank you very much. I hope you can hear me okay. It is, I don't put time in the morning here, very early anyway. It's 8:26 here, so still dark, middle of the winter, but otherwise life is good, and it's great to see so many people, and even better to see that lovely picture of Sydney Harbour Bridge. So it's just a great occasion and a great opportunity for me to be here. So let me begin by thanking Anna for inviting me to take part in this project, to write the foreword and to speak tonight. As I've said to her previously, I think I said privately, let me say publicly, I think she and her editorial team have done a terrific job with this particular issue of the journal. I think unknown to her, I am the editor of the King's Law Journal. And I think she probably also doesn't know that when I took over about 15 years ago, I had a look around at various other law journals to see what would be a good model for us to adopt at King's, or what would be a good model for me to adopt as the editor of the journal. And I did actually fasten on the University of New South Wales Law Journal as a good model, because I particularly liked the idea of thematic issues, which I think the University of New South Wales Law Journal has pioneered for some time. So we have adopted that model, and I'd like to take this opportunity to thank you for having pioneered it, because I think it has been very successful. And it's very successful because it enables you to invite high quality writers or authors to write on contemporary and important topics, as is the case with the issue we're now celebrating. And I think the approach on this occasion has worked spectacularly well. There is a fantastic range of topics, very diverse issues in the field of labour law. They're all very important and contemporary, and an extraordinary range of authors. I think on the labour law issues, the labour law articles, I think there are 6 articles involving no less than 14 different authors. And it really is quite an outstanding achievement. So well done to Anna and the team for producing something which will be of great value, not only in Australia, but for labour lawyers elsewhere in the world. Now, let me move on then, secondly, to just to highlight some of the issues which have been addressed in these 6 different papers. And I hope the authors of these papers will forgive me if I don't name them all individually. It would just for reasons of brevity and to save time, I won't list the roll call of 14, but I think there are copies of the journal available, so it will be easy enough to identify who the different authors are. So when I was reading through the papers before writing the foreword, I think I was struck by, I mean, there are 6 different papers which identify, I think, 6 quite serious problems with the Australian labour law system as it currently operates. And if I just go through these, the first, these are in fairly random order, I should say, not necessarily in the order in which they appear in the journal. But the first issue, I think, is the question of scope, the narrow scope of protection for people in employment, which, as Anna referred to in her introductory remarks, arise in part, but not exclusively, but in part from the recent jurisprudence of the High Court of Australia, which has emphasised this contract-focused approach to the identification of a contract of employment. And that, I think, is very, very disappointing. I mean, it contrasts with developments in other parts of the world, including the United Kingdom, but not exclusively the United Kingdom, where the courts are more focused on the realities of the situation and are mindful, in the words of one of our judges, mindful of the presence of armies of lawyers who are advising employers about how to avoid their legal obligations to their workers by skillful drafting of contracts, and the courts then focusing on the contract and not the reality of the situation. So that would be the first. So in a sense, there's concern about undue formalism on the part of the courts. The second issue, which is highlighted in the papers, is the declining levels of collective bargaining coverage in Australia. And again, Australia is not alone in this. It's a problem which is of global proportions. It seems to be a problem particularly acute in Anglo English-speaking jurisdictions, common law jurisdictions, with this problem of declining coverage of collective bargaining, in most cases now well below 50% of the labour force. And that has major implications for levels of income and voice in the workplace. And in the case of Australia, I think this is particularly disappointing in view of the what were at the time quite innovative steps taken by the Rudd government in the Fair Work Act to promote enterprise collective bargaining. But for one reason or another, as the authors of the paper points out, that promise really has not been realised, and the expectations of the unions at the time and of the government have not materialised. So the third issue, I think, is something which I found quite arresting. It's something which labour lawyers in modern scholarship have tended to overlook, but I think that has been corrected very, very powerfully by the paper in the volume on the operation of what we would refer to as restraint of trade clauses. And these restraint of trade clauses are clauses which, again, inserted into contracts by employers, which are designed to prevent competition after employment by existing employees, but have the effect, of course, of restraining the freedom of employees to move from job to job. And that, I think, is particularly significant at the moment, as we are now moving or have moved into an era of greater labour mobility, where people no longer expect to spend a lifetime career with one particular employer, and do expect to take their skills with them to seek new opportunities elsewhere. But that question is, I think, the case law dealing with that, I think, is very, very well covered in the paper in the journal. The fourth issue, I think, has already been alluded to again by Anna in her introduction, and I think I would refer to this as the bluntness of the equality and discrimination law, which the paper focusing particularly on the question of gender, the question of gender and how that is dealt with in the Australian legislation. And again, this was a very, very arresting paper and a very important paper, which highlights the failure, Anna refers to the question of intersectionality. And this is the issue, I think, which this paper deals with, and in particular, the failure of the legislation to address the situation of women in particular, who are not of Anglo-ethnic origin, who are not middle class, who are not heterosexual or cisgendered, and who are issues also relating to people who are not able-bodied. Now, I think, the significance of this, I think, is it does raise important questions about the ongoing need and the ongoing struggle to ensure that our discrimination and equality laws are constantly revised, constantly kept up to date, and constantly adapt to new knowledge and understandings. Fifth issue has already been referred to, and that is the problem of wage theft, which I understand has now been the subject of legislative intervention. But that intervention would be very, very timely if the evidence in this paper is to be properly understood. And I think the authors of the paper got in before the government with demands for a more robust enforcement of wage payments, tougher sanctions for employers who violate or fail to comply with their obligations, and with better civil recovery mechanisms made available through law to ensure that what are often the most vulnerable, people least able to afford to lose the wages that they have earned, to ensure that these wages are properly paid and adequately recovered in circumstances where there is evidence of a non-payment. And then the sixth and final issue, which is sense going forward, really addresses the challenge of climate change, which I think the authors see both as a threat to jobs, but also an opportunity for new jobs. And here they engage in terms of how we adapt to these new global realities. They engage with the law of unfair dismissal, the law of collective bargaining, the law of occupational health and safety, but emphasize the need for a collective approach to empower workers to deal with the challenges that lie ahead. Now, that's not unrelated to the problems identified by the other paper about declining levels of collective bargaining coverage, which in a sense, but it reinforces the need to address that particular problem. So really, my first thing to say, I think, well, second thing, first was to congratulate Anna and the editorial team, but secondly, to ask the authors to take a bow. I mean, as I was reading these papers and writing about them in the foreword, I have to say that I ran out of superlatives. I think words I used were excellent, outstanding, and stunning. So the collective effect of this group of articles is really quite extraordinary. So that was the second point. The third point I wanted to make then is really to ask the question, what is to be done about this? And since these are fairly damning critiques of Australian labour standards and their operation by labour lawyers operating within the jurisdiction. So the fact that they're made by people internal rather than people like me who are looking in from the outside, I think make them even more compelling. They're strong enough, but even more compelling, given the source of the criticisms and the collective impact of the criticisms. I mean, it's extraordinary to read so many powerful pieces, but the power is all the greater for the combination of them all. So the question is, what do we do about it? What is to be done, as somebody famous once asked? And I guess the problem for labor lawyers, I mean, what people who are not labor lawyers will say, well, don't you labor lawyers always complain? In a sense, you're never done complaining. You're always, malcontent, discontent. There's always a problem. And that is true, because the job of the labor lawyer is never done. In a sense, the standards are never realized. They're never fully realized. It will never be perfect. It's an ongoing struggle to secure better terms and conditions, more equal arrangements, greater voice at work. So yes, labor lawyers do always complain, and they do always complain, not just in Australia, but in other jurisdictions as well. But that brings me to another issue, which I picked up in these 6 articles. Not all of them, but in a number of them. And that is that most of the articles not only offer a critique of the current situation in Australia, but they bring forward proposals for reform. And that, I think, is scholarship at its best. That takes responsibility for the problems that you identify. And some of those who take that responsibility, who address the need for reform, do so by reference to the International Labour Organization. And the International Labour Organization is an organization which has created, or by virtue of membership of that organization, Australia now has a number of treaty obligations under international law. And I'd just like to make a few points about the International Labour Organization, because I think its existence and its operation and its activities are not as well known as they should be. So I'm going to make 6 very quick points. And the first of these is that the International Labour Organization, or the ILO as it's referred to, is a United Nations agency. It was founded in 1919 by the League of Nations, but it was retained after the end of the Second World War to become an agency of the United Nations. Secondly, Australia has been a member of the ILO since 1919 and is bound by the Constitution of the International Labour Organization, which is a legally binding text in international law. And there are 2 provisions in that treaty, in an annex to the treaty, but part of the treaty. The annex is called the Declaration of Philadelphia. And in the Declaration of Philadelphia, there are 2 points which stand out and which need to be taken much more seriously than they are at the moment, not just in Australia, but elsewhere, everywhere. The first of these is a legally binding obligation to ensure a just share of the fruits of progress for all. So everybody within the jurisdiction and beyond the jurisdiction is entitled by international law to a just share of the fruits of progress. Now work out for yourself what you think that means. And secondly, in the same text, there is a legally binding obligation to take steps to ensure effective, and underline effective recognition of the right to bargain collectively. And the purpose of that is to redress what Anna referred to redress the imbalance of power in the workplace, to give workers a voice at work, and to help to raise wages and to equalize incomes as part of the commitment to ensuring a just share of the fruits of progress. So that's the second point here. The third point is that Australia, apart from the Constitution, which Australia has signed up to since 1919 and then reaffirmed in 1944. Thirdly, Australia has ratified 60 of the 190 ILO conventions. And these conventions, like the treaty, or these conventions like the Constitution, these conventions are treaties in international law. And once ratified, as you have done on 60 occasions, once ratified, they give rise to legally binding obligations in international law. Fourthly, Australia has ratified 9 out of 10 fundamental conventions, the most important conventions identified by the ILO. So we've ratified 9 out of the 10 of these fundamental conventions, though at the moment only 8 are presently in force. The 9th will come into force, I think, next year. Now, these fundamental conventions deal with 5 basic issues, very basic. One is freedom of association. 2 is forced labor. 3 is child labor. 4 is equality and discrimination. And 5 is occupational health and safety. It deals with them in the sense that we don't tolerate child labor or forced labor, but we are expected to prohibit and to regulate and to suppress these activities. Now, if we move on to the 5th point in relation to the ILO, and I should say this with some temerity because I'm an outsider here, that Australia is not in compliance with 7 of these 8 fundamental conventions currently in force. Sometimes not in compliance for multiple reasons, as in the case of the freedom of association conventions, and sometimes in the case of some of the other conventions for reasons which are confined to these practices or the situation in particular states. For example, South Australia in the case of occupational health and safety, Western Australia in the case of prison labour, which is a violation of the Forced Labour Convention of 1930. But it's not only in relation to the fundamental conventions where we find Australia to be in breach of its treaty, or at least to be, well, we know that's in breach in relation to the fundamental conventions, but questions have also been raised by the ACTU about non-compliance with a number of the other conventions which Australia has ratified. But the ACTU has not pressed these. But if the ACTU did press these, my suspicion is that there would be findings of non-compliance in relation to several of these other conventions as well, including, for example, the convention relating to workers with family responsibilities, the convention relating to the termination of employment, and the convention dealing with labour inspection and the enforcement of labour standards. So the point is, I mean, really just to kind of juxtapose or to put the current issue of the Law Journal into some kind of international perspective. On the one hand, we have a searing indictment by the authors of the papers in the journal of the operation of labour standards in Australia. And Australia is much better than many other countries, it should be said. But nevertheless, one explanation for that is the fact that Australia is failing significantly to meet its international legal obligations. And I was, when I was preparing the foreword for the journal, for this issue of the journal, I was reflecting on whether there are other legal disciplines. Can we think of any other course on the curriculum where this non-compliance with international law is so complete? And reflecting also, why is it, if it is so complete, are there any other, would we tolerate this with such indifference if this were to be the case in relation to any other discipline that you may have studied in the course of your law degree so far? So the point is really 2 things. One, we shouldn't be surprised, I guess, is what I'm saying, about some of the issues that have been raised by the authors of these papers when we look objectively at the evidence which is provided by the agencies which supervise Australia's non-compliance or compliance with its international treaty obligations. So in conclusion, let me just make a few points. One is to say that Australia is not alone in its non-compliance with international labour standards, and certainly it ill behoves me from the United Kingdom, of all places, even to speak about this, because in the United Kingdom it is even worse, even much worse, the position here in terms of the failure properly to comply. However, I have to say that when I asked earlier, when we identified the problems which have been raised by the authors, and I asked the question, what is to be done about it? And it takes us into all these ILO problems. I would suggest that we could begin addressing the concerns raised by the authors by committing to our legal obligations, not just in Australia, but in other countries as well. Commit to our legal obligations in international law, and in Australia to begin that commitment with a review of what needs to be done and how long it will take, because it won't happen overnight, how long it will take. This is something that's been going on for 30, 40 years, this slide. How long it will take to bring domestic law into line with these international standards. And I would conclude by saying this, that the authors have shown, the authors of this issue have shown that there is no shortage of brilliant labour lawyers in Australia who could conduct or contribute to that exercise, which I think is now needed. What needs to be done to bring Australian labour law into line with Australia's international standards? And having identified some deep and fundamental problems collectively, it seems to me that the authors of this volume are well placed to provide the solutions of what needs to be done, solutions informed by legal obligations which arise under international law. So thank you for listening. And thank you again to Anna and for the other members of the editorial team for the opportunity provided to me to write the forewords and to speak to you this evening. For me, a new day dawns. I can see the darkness is fading. For you, I guess it's the end of the day at a time for celebration and some social activities. But I would just say, really, to echo something that Anna said at the start, that when you enjoy that drink and when you enjoy your off time tonight, just think about the people who are there to provide the service which you will now enjoy. Think about the workers who are making your life that much more enjoyable this evening. Thank you very much.
Thank you very much for that address. I'd like to also start by acknowledging that we are here on Gadigal land. I don't think I can add anything to the beautiful acknowledgement we had earlier other than to point out how amazing this land is onto which we're all looking at the moment. I'm here representing Andrew Lynch, the Dean of the Faculty of Law and Justice at UNSW. He's very sorry he couldn't be here tonight. I hope I'm not a poor substitute. I'm certainly a much shorter one. I'd also like to thank King Wood Mallesons, in particular Andrew Gray, for hosting us here this evening. It's always lovely, both the officers, the food, everything, and all the people who've contributed to that. And I join in the acknowledgement of everyone who has served drinks, manned cameras, taken photos, including with umbrellas, and sort of really made everything happen, which is fantastic. So thank you, Andrew and King Wood Mallesons. I'd also like to acknowledge, as others have, the other premier sponsors of the journal, Allen's, Herbert Smith Freehills and Cause Chambers Westgarth. Good, excellent, got that right. I'd like to thank Gary Edmund and Rosalind Dixon, who are the faculty advisors for the journal. Can't find Ros anymore. She was here. I saw her before. Anyway. Yeah. I'm blind. Okay, clearly eyesight issues in my age, but it's a really important role. It's one I played many years ago, so I understand its importance. The faculty has a huge love for and has always supported the journal, and it is a role that sort of creates that link between, the faculty itself and the student editorial board. I'd like to thank Professor Keith Ewing for a fantastic keynote that highlighted a lot of issues and has certainly left me with a lot to think about, as well as the editor of the issue, Anna, as well, and Ho for her putting that together. There's been a lot said about it already, and I won't add too much to that, but a few things that really grabbed me, and I'm not a labour lawyer, so I think the idea that we are all workers that Anna raised at the beginning is a really crucial one. This is a category into which we all fit. The point that was made about that Professor Ewing made about the sort of disappointing nature of Australia's compliance with international law in this regard, and indeed Australian labour law, and some of the concerns that were pointed out, and the importance of the papers in highlighting and pointing a way forward for Australian labour law, the very important role of international law and the International Labour Organisation, an institute I've had the pleasure of visiting and seeing some of the sort of representations of the importance of labour in the art that's in the building there. But also, I suppose, the idea of what it might mean, right, to really take these kinds of obligations seriously. What would it mean to share in the fruits of progress? One thing, I'm not a labour lawyer, I am a technology lawyer, so I do see a lot of what's happening with things like artificial intelligence. And it seems to me that the fruits of that are very much not going to people or workers and so forth. And we have to sort of, I suppose, rethink in a world where humans are working alongside systems, how we can still ensure that it is actually the humans that are enjoying the fruits of that greater efficiency and so forth. So echoing very much what was said, and with thanks to both Anna and Professor Ewing for putting that so succinctly in their remarks. I'd also like to thank everyone involved in the journal. It is a huge endeavour to put something like this together. The members of the editorial board, for their always careful editing, is incredible. I've yet to spot an error that wasn't picked up in the editorial process after many years of reading the journal, which is an incredibly impressive feat. I've worked previously in the United States, and one of the things there is being a member of a journal editorial board is very much recognised as a career highlight. In fact, professors, Supreme Court judges will still tell you that they were on the editorial board, that they were executive editor of a journal and so forth. And I hope very much that those here from firms will similarly recognise the great work that you have all done and the importance of that work, both as a contribution to academic scholarship, but also very much as a great way to learn about the law. As well as the editorial board, a particular thanks to the leaders. I've mentioned Anna and her role in the issue, but in fact, all of the leaders of the journal. If UNSW Law Journal is the best law journal in Australia, and it is, then that is very much due to the leaders, both past and present, of the journal for bringing it to the heights to which it continues to accomplish. And a final thanks to the audience for coming. It's always great to launch a journal live, and we now know from the pandemic what an honour and sort of special thing that can be. So thank you, everyone, for coming. Thanks again to all of the workers, which I think is everyone in one capacity or another, but particularly those who've been here supporting the event and all the work that goes into that. So I think I am now literally the only thing between everybody and going back out to continue networking. So thank you for having me, and thank you all again.
Thank you, Professor Bennett-Moses, for that lovely vote of thanks. And thank you as well again to Professor Ewing for that insightful keynote address. Well, that brings tonight's official proceedings to an end, but do feel free to remain and mingle for another half hour or so. And please don't forget to pick up a complimentary copy of the journal before you leave. The journal is also available in digital form on our website. Good evening.